Makes me jump every time. Okay, so welcome everyone. Thank you for being here tonight. My name is Jana Wordy. I'm the Executive Director at the Dutchess County Bar Association. This is the first of our seminar series. Tonight's topic is why you need a will. These seminars are made possible through a grant from the New York State Bar Foundation, so we're very grateful for their support. Tonight, our presenter is Rachel Flanagan Frost. She's a trust and estates attorney located in Fishkill, and she's going to talk to us about why you need a will. So I will turn it over to her and just ask that while she's presenting, we all mute ourselves so we don't get any feedback or background noise. And at the end, we'll have time for questions. Thanks, Rachel.
Good evening, everyone. So my name's Rachel Flanagan Frost. I'm an attorney. I have my own practice. I primarily focus on wills, trusts, and estates and probate proceedings too. So I see the beforehand and the aftermath as well. So the discussion that Jana had asked for me to talk about tonight is why you need a will. So I'm going to be a little more specific than that and talk about basic estate plan documents, what they consist of and why you need them or don't need them and what they're for. So I would kind of want to talk about in two basic categories. One would be living documents versus death documents. We'll call it that, not to be morbid, but to kind of get the point across. So living documents, what I consider living documents for our discussion tonight would be three things: a living will, healthcare proxy, and a power of attorney. So again, before I even get started about this stuff, just to be clear, we're talking New York specific, right? So estate planning, all of these things are governed by state law. I'm admitted to practice under New York law, so I can only give you information pertaining to New York specific rules. So as far as living documents are concerned, these three that I've identified here are very important while you're alive. Again, to be clear, these documents, the authority under them actually dies with you. The importance of these documents would be, God forbid, something were to happen to you and you become incapacitated or unable to do something, have too much going on, overwhelmed, sick, lying in a hospital bed, in a coma, etc., and just unable to handle your financial affairs, unable to make medical decisions. Without documents in place, it makes it very difficult for your loved ones to be able to step in and handle things on your behalf. So the point of the documents is a couple of things. Number one, it gives legal authority to somebody else so that legally they can just step in your shoes and be able to handle things while you're alive. Another importance of the documents is to have things in black and white so that your loved ones know exactly what to do in the event of an emergency, rather than allowing it to be a guessing game. So starting with healthcare decisions. So healthcare decisions are obviously very important. If you're unable to make those decisions on your own, you want to make sure that you pick somebody in advance while you have sound mind to make those decisions, to be your advocate. It's a very important role, obviously, because in the event you're in a grief-stricken situation, you don't want your loved ones or people close to you to be scrambling to figure out what to do and who should be in charge of it. So starting with the healthcare proxy, it's a very basic form, basic document. It's something you definitely need, where you're naming a particular person to be able to be your medical advocate. That person will have the authority to be able to speak to doctors on your behalf, get medical information under the HIPAA releases that you sign off on. They'd be able to ultimately make medical decisions, so they could pull a plug, God forbid, something were to happen and there was no quality of life. They'll be able to decide if you need a surgery or don't need a surgery. They'll be able to decide if you should be transferred. So if you should be moved to a better facility. You're making sure that you're naming somebody who has that type of authority. You also want to make sure when you pick people for these roles that you're picking somebody that would fit the role, right? So a lot of people ask, who should I name? I don't want to hurt one person's feelings over another person. So some people end up deferring to that type of thinking where they pick somebody based on, hurt feelings. You want to be careful doing something like that, because again, in this situation that you're naming somebody to be your advocate, you can't change it. So if you're incapacitated, you're going to be unable to change it at that point. So you want to be smart in who you pick. Who do people typically pick for this type of a role? It depends on the family dynamic. So typically, if you're married or you have a domestic partner and you've been with somebody for a long time, typically people will pick that person first, but it's good to have alternate agents, of course, right? So you should have a second backup, maybe a third backup. You can go right down the line. A lot of people will choose their adult children for these roles as well. You want to talk to them and make sure they understand that you've done it. Some people choose a close relative other than that, a sibling, a parent, a cousin. Some people choose a friend. It really just depends on their background and your trust level for them. So that's why that document is so important. Also, if you do sign one of these documents, you want to make sure you give access to the document to the person you've named, right? Some people make the mistake, they create these documents, but then they keep it private and don't tell anybody. So obviously you have to make sure that the people you've named are well informed and maybe even have a copy of the document. You could even file a copy of this document with your doctors to make sure that everybody's on notice of who to call in the event of an emergency. Another document that's used with the healthcare proxy, some attorneys will put it actually contained inside of the healthcare proxy. Some people draft it separately, would be a living will. So a living will, some people call it a DNR. It's not exactly a DNR. What a living will states is basically your wish list, meaning if in the event you were in an irreversible and or incurable mental or physical state with no quality of life, at that point, you don't want to be inevitably plugged into machines, right? You wouldn't want to be on life support, artificial hydration, nutrition, being on a vent or respirator if there was no quality. If the doctor said he or she is brain dead with, not much quality of life left to live, at that point, you want to be inevitably plugged in. So the living will is a very subjective form, by the way. It's not enforceable in New York State. It's basically just telling your agents so that they can feel more comfortable in the end making that decision, so they don't have to guess as to what your wishes are. That's why that document is so important, because if it got to a point where you were with no quality of life, no real chance of recovery, do you want your healthcare proxy to ultimately make a decision to let you pass peacefully, or do you want them to keep going and get more opinions? So living will is important just to make it more peace of mind for the people you've named, so that ultimately they can feel more comfortable if they have to make such a big decision. So that's kind of the healthcare documents. And the reason why I say the living will is not enforceable is because it's so subjective. That document, let's say right now, I don't know I know some of you that are here, but I don't know everybody here. So let's say you're not in end stages of something, you've signed a living will. Obviously, the living will has no authority right now. It really just jumps into effect should something happen in the future. It's much different from a DNR or MOLST form, if anybody's heard of that. A MOLST form is that bright pink form you can get from the doctor's office that's signed by a doctor. That one's much different. That one's saying that you're already in the stage where there's no quality of life. You're already in end stages of something and that you don't want resuscitation. So that's a much different form. The basic living will that you can get in the Department of Health website or through an attorney is much more simplistic and much more subjective, but still important. The other document that I'll call a living document is a power of attorney. The power of attorney could even be a higher priority than the healthcare directives. The reason I say that is because power of attorney, there is no default under the law. With healthcare decisions, ultimately, if you don't sign a healthcare proxy, well, it's not advisable if you don't sign one, but if you don't, there is a medical act out there that allows doctors to defer to next of kin. So at least there is some type of protocol. Power of attorney, not the case. If you don't name a power of attorney and you become incapacitated, you've left your heirs or your loved ones with this issue where they're going to have to retain an attorney and potentially file for guardianship over you. So that's why power of attorney could even be more important. Power of attorney is the financial counterpart to the healthcare directives, right? So the healthcare directives, just medical. Power of attorney is really everything else. Power of attorney is a way to allow someone else to step in your shoes, so to speak, right? So this person, you're giving them the ability to buy and sell real estate, buy and sell personal property, access your bank accounts, pay your bills, business operating if you are self-employed, insurance, estates suing on your behalf, giving gifts, signing your tax return, arguing medical bills. Power of attorney is really giving someone else the ability to be you in the event you're unable to act. Power of attorney is also a very difficult document, let's say. New York State is very strict with this document. It's very different from the healthcare proxy. Healthcare proxy, a lot of times, if you walk into a doctor's office, they can give you a copy, an unsigned copy. Obviously, you can fill it in and sign it in front of 2 witnesses. You can even access a copy of a healthcare proxy form right online. If you go to the New York State Department of Health webpage, they have a template form there for you. As long as you sign it in front of 2 witnesses, those witnesses are not your agents and they're over the age of 18, there you go, you have a valid healthcare proxy. Power of attorney, however, buyer beware, trying to do the power of attorney on your own is a little bit more risky. You might be able to get away with filling out the basic template boilerplate form, but you very well may not have all of the provisions that you really need to have in this document. New York State has changed the law with power of attorney quite drastically over the years. They had one really big change in 2010, and they just recently changed it a couple of weeks ago. So you have to be careful which form you're finding. You could find the wrong form online. So power of attorney, typically I would advise to get advice from an attorney to prepare one. Power of attorney, you have different options. You can have a primary agent. You can have a backup agent in case the primary is unable or passes away, God forbid. And you can have a second backup, a third backup, whatever you want to do. You can also have co-agents. So some people have, a spouse and a kid that they want to serve together, or a spouse, second marriage, and kid from first marriage that they want to serve as co-agents. With that, you can also create the power of attorney to be flexible, or you can make it so that it's much more strict. If you make it flexible, then the agents can act separate, so they have the ability so that if one's too busy, the other one can step in, and vice versa. Or if there's some hesitation with the people that you're naming, or you just want to make sure that there's definite checks and balances, then you can force them to have to act together. From a practical standpoint, sometimes that can be a little difficult for that person to be able to act, but sometimes the dynamic calls for that and you need it. So you need those safety guards. Other things that you can do, again, you can have other backups, you can have co-backups. Another optional part of the form is there's a gifting provision. So the new power of attorney form limits gift giving at a cap of $5,000 per year. So gift giving isn't just what you think of. It's not just writing birthday gifts and holiday gifts or presents to people, but gifting is also the ability to add and change beneficiaries. So that's something that is very crucial that a lot of times is overlooked. The reason I say that is because a lot of times, especially if you go to an attorney and you're doing your estate planning and you want to make sure that things are covered and that you've avoided probate perhaps for your spouse or your kids, and you go and name beneficiaries on things, or maybe you never got around to it. The power of attorney can bridge that gap, because if you give your agent under the power of attorney the ability to do gifting, if you forgot one account out there, the gifting provisions will allow your agent under the power of attorney while you're sick to go in and add your beneficiary the way that you wanted it. Of course, that brings with it some risks too. You're giving your agent the ability to change your beneficiaries. So you'd want to put some limitations and get proper advice as to how to set that up, but it can be a very smart and necessary estate planning tool as well, in addition to be able to obviously name somebody to be able to pay your bills, but it can be so much more than that. So you really need to be careful with that document and make sure that you have proper advice before you set one up. Now, just something quick about the change in the law. So if you have found an old power of attorney form, that predates the 2021 form, or you had a draft from somebody that prepared it for you, don't go sign it now after the new law is in effect, because you're going to have an invalid form. You have to use the new form post this new date. So you just have to be careful with what you have. If you have an older form, it doesn't mean that it's invalid, but you might want things to be looked over by an attorney just to make sure that you're good to go. But again, just because you have an old form doesn't mean that it's invalid, but you do want to make sure that you have those gifting provisions just in case. So it's something to keep in mind. And with the power of attorney, just so you know, the new law requires this document to be signed both in front of a notary and 2 witnesses. So if you are going to sign your own power of attorney post this month, because it was just effective this month, and you don't have witnesses, then you have the wrong form. So it's just something to keep in mind. Power of attorney is a little more risky, right? When you're naming somebody to be able to handle your financial affairs. So this document you may not want to hand out to all of your heirs, but it is something important to make sure that they know that you've done and where you plan to keep it. So healthcare directives, you definitely want to pass those out because anything could happen in the middle of the night or during a holiday, and you want to make sure your agents have the requisite authority to make your medical decisions. Power of attorney, it ultimately depends on the family dynamic. So you can pass them out, of course, to your family, knowing that once they sign it, they're able to act. Or you keep it close to you, keep it at home in your filing cabinet and make sure that they know where it is. So those are your three most important documents, in my opinion. The reason I say that they're most important, it doesn't really have to do with your estate plan or death or your assets, but the reason I find them most important is because you're deciding when you can to be able to name somebody to be your advocate while you're alive. That's why I find that to be the most important. Not diminishing assets or where things go when you pass away, but I do find that a priority, you being your own priority, of course, and your spouse and or domestic partner and children. So it's just making sure that you have those proper things in place. Switching gears to death documents, other things that are important. Part of the title of this seminar is about why you need a will. So other death documents, there's two other basic ones. So I'll start with the really easy one. There's a form that's specific to your funeral arrangements. So it's called an agent to control disposition of remains. I believe that one's also available online. You can get it from a funeral home or you can have your attorney do it. The purpose of that form really is just to name an agent to make sure that someone has the requisite authority to make your funeral arrangements. Typically, funeral directors will defer to next of kin without the form, but not everybody has a simple next of kin situation, right? So it could be, again, you're not legally married, but you've been with somebody for a very long time. They're not your default spouse in New York. That's not how it works. So you want to make sure you have these documents in place so that you can decide now who's going to be in charge of these arrangements. So that form is important, of course, because again, to be clear, your power of attorney, your healthcare directives die with you. So the funeral can't be made. The will doesn't come into effect for a while, if at all. So we have your funeral arrangements that need to be made rather quickly, immediately after your death. So that form just kind of bridges the gap. It's a very simple form. Again, you're just naming a person to make those decisions and maybe a backup or two. And then you have the option in the form to be able to name specifically what arrangements you do wish to have, right? Cremation versus burial. Some people get more specific than that. So that's what that form is for. And then the final estate plan document, the basic document that's important, another death document is your last will and testament. The idea of the last will and testament is that it basically states where your assets are to go upon your death. A last will and testament, though, to be clear, when you die, is not automatically probated. It depends on how your assets are titled. So you have to be very careful with how you structure a will and or how you structure beneficiaries attached to your accounts. So the way that it works with probate, just to kind of explain that so you can understand the concept of the will. Probate is a process whenever you own something in your name alone that has no joint owner, no beneficiary, no trust owning it, and then you die. That asset, because there's no name attached to it, now is subject to a court proceeding. That court proceeding is called either probate or estate administration. That process is when the will comes up. So the will only comes up for assets that don't have names attached to them at death. And now the will say where your assets are to be distributed according to those terms. So a will does not govern assets that already have beneficiaries on it. So to be clear, let's say your goal in your will is that you want your assets to be divided among, I don't know, 2 of your kids and a best friend. But then on all of your accounts, you have 3 kids and 2 cousins listed as beneficiaries. The beneficiary designations win. Beneficiary designations against accounts, that supersedes whatever your will says. The will really governs what is left over. So if all of your accounts have designated beneficiaries on it and your will says something else, then your will might not actually govern anything because there might not be any need for a probate proceeding. So you have to be careful to figure out what exactly it is that you want to happen at your death and what's the best way to go about it. If, for example, you own real estate and other types of assets and you don't have a trust, then your will is going to govern, at the very least, your real estate. If you have no joint owner, if you don't have a life estate deed and there's no trust owning that property, then that property we know is going to go through probate because no name is attached. The same might very well apply to bank accounts. If you have a bank account with no joint owner or beneficiary attached to it, now we know the will govern that too. Same thing with anything else, retirement accounts, life insurance. If there's no beneficiary, then that's all going to go through an estate proceeding and your will govern that. You can avoid a will having to be used for assets by making sure you have beneficiaries on everything. That can avoid that process to speed things up so that at death things can automatically go to your heirs as opposed to them having to go through a court process. It's a common misconception with wills that, I've written my will, why can't my kid just run to the bank with it and everything goes to him? Because a bank's not qualified to look at a will and determine its validity. Only a judge can. That's how it works in New York. So that process, you can't avoid it if there's no beneficiary on an account. Then that account must go through probate. There are, of course, some exceptions to that, but I won't get into all of those little things. So the idea is a will important? Yes, of course it is, because what if you end up having probate? The other question is, well, what if you are sitting there saying, well, I don't have any assets left out, right? I have a beneficiary on all of my accounts. So there's no issue here. It's going to go to my beneficiary. So what's the purpose of the will? The will is just in case. What if some other asset fell through that you weren't expecting? Or what if there was a lawsuit at end of life? God forbid, you get hit by a car and now there's a settlement and money's coming into the estate. You can't avoid probate for money that didn't exist before. Or you prepaid for a nursing home for 3 months, so now $50,000 is coming back into the estate, a refund check. Those types of assets now are governed by the will if you have one. So of course, you always make sure you have a will to make sure that it says what your wishes are for those hypothetical assets as well. The other thing about a will, so let's say you don't have a will, what's the default? In New York, I get this a lot where, I've had clients where I've had to give them a very unfortunate news where they've been domestic partners for, let's say, 35 years, and they just assumed that New York State has common law marriage that would be recognized at death and everything would just be automatic and go to the spouse. But that's not how it works in New York. So if you're with someone that you consider to be your spouse, but legally you're not, again, that's a very important reason to get these documents in place so that you can make sure that they're treated as though they are your spouse. Because they don't have any rights at death because New York State doesn't recognize that in a probate context. The default under New York when you don't have a will, if you're married and you have kids, the first $50,000 goes to your spouse, then 50% of the residuary goes to your spouse, the other 50% is then going to your children. That's not always your goal either. So again, a lot of people assume when you're legally married that the default would be the spouse, but that's not the case either. So that's why you want to make sure you have a will to govern what those wishes are. And then the other consideration I've had a lot of people ask, where I've had to sometimes ask very intrusive questions to kind of get to the bottom of the dynamic, stepchildren. Some people will consider their stepkids to be as though they're naturally theirs, right? I had a client recently who had told me that he had 3 children. And as I'm asking a lot of my rude or offensive questions, come to find out that the oldest of those children wasn't actually naturally born to the father. He raised that child since that child was maybe 3 months old, so just never considered that child anything other. But again, if he wasn't more clear and I just wrote a will that says I give everything to my children, wouldn't have been good enough because a stepchild wouldn't be included unless you specifically reference that. So again, you just have to be careful to make sure that your will states what you want it to state, and we shouldn't leave it up to New York State. It does not mean that it's going to go to the state. That's also a common misconception because there are those defaults. There is a next of kin statute that says where everything goes if you don't have it in writing, but we don't want to necessarily leave it up to that. I've had other clients where their next of kin is really difficult to find. Could be some random second cousin that they have no relationship with, and they'd rather it go to their partner or, I don't know, a close friend or charity, but they never got around to signing a will, so it's no good. Or they've met with an attorney but never actually signed anything. That's not good either. I've had people ask, well, I've had this appointment, you have your notes. Wouldn't that be good enough if something happened tomorrow? It's not. There are a lot of rules in New York State about how a will has to be executed, which is another thing to be careful about as far as the whole do-it-yourself wills. Do-it-yourself wills, buyer beware, just like I said with the power of attorney. The healthcare proxy, that's easy. That is much easier to do on your own. Like I said, even if you go into a doctor's office, they'll hand you a form if you ask for one. Plus, you can get one right from the Department of Health website. Power of attorney is a little more risky. A will is even much more riskier, right? So I do probate proceedings. So I've had to do probate for wills that have been done through the online software or do-it-yourself forms. Those probates typically end up costing 3 to 4 times as much as a regular probate, because a lot of times there are errors in these wills that people don't realize, because either the software was not proper, or it wasn't state specific, or it's missing certain language that's required. So you just want to be careful. And that's why that document could be so important. And you just want to make sure that it's done correctly. So that's kind of my spiel on the basic documents. We have, again, the living ones, which are the living will, healthcare proxy, power of attorney. Those are, if I had to prioritize, those are the absolute most important, because those protect you while you're alive, you and a spouse. The other thing I should have mentioned earlier, a lot of people assume that you're married and your spouse naturally can do all of these things on your behalf. That's also not true. So you want to make sure that you have these things in place. So for example, power of attorney, you're married and your spouse has a 401k, you haven't started pulling your distribution yet. Your spouse gets hit by a car at age 71, is in a coma for 3 years, let's say, and spouse turns 72, you need to start taking the minimum distribution. Well, healthy spouse has no authority to call up that 401k company to pull the distribution out. Just because you're a spouse doesn't give you that type of authority. Power of attorney gives you that type of authority. So again, just to be clear, those are the 3 most important, to protect yourself, to protect your spouse if you have one, your partner if you have one, your children if you have one. And then the death documents, because of course it is important to what happens after, and you want to make sure that all that's covered. And that's the funeral form and the last will and testament. So that's your basic estate plan. Of course, there's other stuff, there are trusts, there's more getting into detail with beneficiaries and that kind of thing. But this lesson today was really just for those basic must-haves.